Welcome, everyone. Thanks for joining us for this session, Promise or Peril Towards an International Data Protection Regime. This panel is organized by ASIL's International Law and Technology Interest Group, and it is co-sponsored by Deckert, LLP. I am the co-chair of the International Law and Technology Interest Group, along with Harry Osofsky and Deborah Husen-Curiel. My name is Arturo J. Carrillo. I'm a professor of law at George Washington University Law School here in DC, where I direct the International Human Rights Clinic and co-direct GW Law's Global Internet Freedom Project. I'm joined today by four outstanding panelists. I'm just thrilled to be here with them. And we will be together addressing one of the most pressing issues in transnational legal practice today, that of data protection and privacy rights, and why we can and probably should begin to talk about an evolving global data privacy regime in international law. Among the questions we'll be addressing today are the following. Is the EU's General Data Protection Regulation, the GDPR, becoming, as many believe, the global standard for data privacy? What alternatives to the GDPR model exist in the US and elsewhere? What challenges has the global pandemic, the COVID-19 pandemic, presented to rights-based data privacy regimes like GDPR? And finally, how does technology drive or impede the development of such a data privacy regime in international law? So those are some of the things we'll be looking at today. I'd like now to introduce briefly each of the panelists, and I'll ask that they provide additional background when speaking, because there's a wealth of experience and perspective here, and I'm just touching the tip of the iceberg. We'll start off with Odia Kagan, partner at the firm of Fox Rothschild, where she is the chair for GDPR compliance and international privacy. Thanks for joining us, Odia.
Hi.
Liesl Bruner is the director of global public policy at AT&T, and formerly a policy director at the Global Network Initiative, where I had the pleasure of working with her for a number of years. Thanks for joining, Liesl. Then we'll hear from Margaret Hu, professor of law at Washington and Lee Law School, and currently a visiting professor with the Keenan Institute for Ethics at Duke University. Nice to see you, Margaret. And we will round out with wisdom from Dr. Andrea Matwishin, who's Associate Dean of Innovation and professor at Penn State Law, where she's also a professor of engineering. So that's a unique perspective, and we're so glad you could join us, Andrea. Before I start to converse with the panelists, I want to just give a brief introduction to this topic. And I want to refer to the online symposium published by AGIL Unbound. So that's the online edition of the American Journal of International Law. And that symposium, which was published earlier this year, is entitled The GDPR and International Law. And in it, various authors explored why and how that particular internal EU regulation was evolving into what many are calling a global data privacy standard. There were also some very interesting articles critiquing that position. You know, the GDPR itself doesn't need a lot of introduction, I think, to this audience, but I do want to highlight some of the topics that justified a full symposium issue and that we will be addressing in the course of this panel. So on the face of it, the GDPR is directed toward EU member states and has immediate and binding legal effect within those countries, obviously. But critically, it also applies to any organization operating within the EU or offering goods or services to customers or businesses within the EU. So this is that extraterritorial component or dimension that underpins the claims that this particular standard is becoming the global regime. So it's that extraterritorial dimension that of the GDPR and its regulatory duties, the duties it imposes, that don't just bind companies and organizations in Europe, but any outside of Europe that want to do business there. And this, of course, is where the action lies. And this has had an effect. This dimension of extraterritorial effect has had an impact not just on non-European companies wanting to do business in the EU, but also countries outside of the European Union who are enacting or updating data privacy regimes. So I currently have a research project into Latin American data protection law that looks at the impact of the GDPR. And it's been, historically, European law has always had an effect or influenced the evolution of Latin American data protection law. But the GDPR's effect has been particularly outsized in countries like Argentina and Brazil. Have either proposed or enacted, respectively, new legislation that would reflect a great deal of what's in the GDPR. So it's having this global impact. Some of the duties that are involved in that sort of influence include the need to obtain affirmative consent of persons by data processors or controllers of the persons whose data they hold or gather. The obligation to rectify or erase at the request of data subjects any information, any data on that subject. And of course, the restrictions on data transfers of user data from Europe to outside the European Union. So these are some of the main duties involved in this global reach that the GDPR is apparently having. Now, critics of that proposition that the GDPR is evolving in this way point to different approaches being taken, most notably here in the United States and within the United States in California, to regulate data privacy. Now, I'm referring to the California Consumer Protection Act, of course, the CCPA, which is also evolving, recently regulated, and and is likely to have, if not already having, far-reaching effects as well. So, to help clarify this bipolar dichotomy I've set up of the GDPR on the one hand and possibly the CCPA, excuse me, on the other, I'd like to call on Odia Kagan to talk to us, as a practitioner from your experience and what you're seeing out in the world. Let's start with what the effect of the GDPR has been on your practice. Now that we have 2 full years of its being enforced under our belts, what is it you're seeing out there?
So GDPR by itself, not even mentioning GDPR's influence in bringing about CCPA, which I think it had a large part. GDPR by itself affects a lot of US-based companies. I have worked with literally hundreds of US-based companies on their GDPR compliance, because if you are a US-based company in the US, even without an EU presence, obviously if you're a multinational and you have subsidiaries, that's obvious. But even if you're just completely US-based, and even if you are a service provider that is based in the US and provides services to companies that are either EU-based or subject to GDPR as a non-EU data controller, then you have obligations. And the obligations are even though GDPR has a very clear extraterritorial application, and Article 3.2 applies to companies that set out to provide services to individuals in the EU, even if the enforcement itself on non-EU entities with no EU presence whatsoever is currently a little bit murky, and we were told that this is going to maybe not be murky soon because the EDPB is working on guidelines about this. It's really important to note that there is a huge impact on companies and how they do business because of the commercial aspect of it. If you are a service provider, then even if GDPR won't apply to you directly, you have companies that are your clients that are looking for a certain standard of data protection from you, because they are obligated to show that their entire downstream is compliant. And consequently, they won't do business with you if you cannot demonstrate to them that you are able to protect them. So it's really been, I think, even without that, cross-border enforcement actions, the influence on US-based companies from GDPR has been remarkable.
And now there have been some complaints. You mentioned enforcement, so you're seeing that there's that might become something a bit more concrete in the future. There have been some complaints that it's not actually having any, there's no enforcement behind the norms. Is that something that you're facing or dealing with?
So I think that the enforcement debate is an interesting one. uh, there are a lot of there's a lot of talk out of particularly Germany and the German supervisory authorities, the local DPAs, about how there isn't enough enforcement and pointing fingers specifically at Ireland and at the UK for that particular issue. I think part of it is um, so conceptually, right? You can always have, I guess, more enforcement, and it depends on what you're looking at, right? And it cuts both ways. I think that one, the influence of GDPR is kind of, it's clear even without these big dollar items. Yes, do I talk to companies that have been around and have been in Europe for years and years with the directive and everything, and I still see that there are some things that are missing? I'm like, how is this possible? Like, this has always been the law for you guys. What's going on? Yes, that's true on the one hand, but on the other, I mean, there's these things are like they're it takes time, right, for it to kind of trickle down. And the other is that we do see enforcement, right? So for us in the US, kind of looking from the outside, right, it's, I think, difficult to gauge the true impact of all of the enforcement, because we are aware of kind of the 50 million euro thing and the notice of fines for like really big ticket hundreds of millions of euro. But if you look, and there are a bunch of these enforcement trackers that are coming out, and if you look at the enforcement actions, there are enforcement actions on by the individual supervisory authorities that are coming out all the time. They are 5-digit fines, they are 6-digit fines, they are no fines at all, but rather like the French Canil, hey guys, you have 90 days to fix this or else, right? And those, I think, probably when you're on the ground in Europe looking at what's going on, that this is impactful. And the other thing to remember for Europe is you can like file a lawsuit for certain things, for certain using GDPR as a cause of action in certain cases. So that's also something that's happening.
Well, that's really helpful to clarify not just the normative reach, but the fact that there is some weight behind that. There is some action behind the norms in the GDPR. And so moving on to the topic of the CCPA, which is being held out as this rival, this competing norm, even though you mentioned it's been influenced by. What's the interrelation between the two sets of norms, and to what extent do you think the CCPA is competing with or furthering the GDPR framework?
So I think the one important thing to note is that I think that GDPR and having been entrenched and the really excellent PR machine the GDPR had worldwide definitely contributed to CCPA coming into effect. Because it gave like the impetus for, okay, we need some sort of vehicle in order to enforce, particularly, by the way, for CCPA, the idea was, okay, we need to enforce against big tech. And how do we do that? Okay, well, a comprehensive data protection law, that's a tool that we can use. Look, it's working somewhere else. So I think in that sense, that is one contribution. The other is that a lot of the concepts from CCPA have been based on or loosely based on or influenced by GDPR. They are not a one-to-one translation, and that is something that some people support and some people object, but it's a very kind of intentional different implementation intended to match the approach in the US, which is in a lot of cases different than GDPR. So first of all, the similarities, right? And when we talk to companies about, I think the one thing that is important to note, and this is also something that I tell clients when talking about what are we going to do if we're going to have 50 different US state privacy laws, how do we comply with this? If you differentiate between kind of to use a tech metaphor, right, the user interface, the GUI kind of thing, and the back office stuff, right? The stuff behind the scenes, there is a lot of commonalities between CCPA and GDPR and the other laws. What? For example, what? One, expanded disclosure, right? CCPA, same as GDPR, you need to tell people a lot more about what you're doing with their information and why, and who do you share it with and why, than you needed to before. Number two, there are rights. people can have some sort of choice and control with respect to their information, including access, including deletion. And the third big picture kind of commonality is like buttoning up your downstream. You are responsible for your service providers, and you need to make sure that they are also in line. Now, the implementation of all of these concepts is different. The level of disclosure, a CCPA privacy notice is different than a GDPR privacy notice. The CCPA does not have the concept of a legal basis. There is this sort of assumption that we're starting from a point of, okay, this is okay unless we tell you no, and as opposed to looking at a reasoning, and the opt out of sale versus the opt in. So that's, for example, right, using an opt out approach is very much in line with the US tradition. Can spam is opt out based. There's a lot more opt out kind of approach than GDPR, which is opt in. So I think it was influenced by GDPR. The concepts are similar, but the implementation was intended to fit with US based traditions and approaches.
Well, thank you very much for that clarification, Olivia. That's very helpful to see how the two relate to each other. Obviously, representing very different sort of legal cultures and approaches to the notion of privacy rights. Um, uh, so let's move on now to the next panelist, Liesl Brunner, and hear from the corporate perspective, but also with the strong human rights experience behind it, about what the impact of GDPR looks like from the corporate side of things. And so talk to us a little bit about, you know, AT&T's global business and what you're dealing with in this respect.
Of course, thank you. And I come to this from a public policy perspective rather than a compliance perspective. So from the policy perspective, I think we and many in multinational business welcome the fact that GDPR provides a consistent regime for the collection and use of personal data. It applies to all parties in the ecosystem, even to governments, and it's comprehensive. A lot of the attention has been on kind of the access and the deletion rights, but in some ways, the greatest impact has been on the privacy management instructions, which AT&T and many companies, I think, have used to create a global privacy program. The requirement to conduct privacy impact assessments, to have a chief privacy officer or data protection officers in different regions, to document your data flows, to track them down and figure out which data is going where, to implement privacy and security by design. Those are the kind of things that a company can implement worldwide, and so that even in countries where, for example, there is no obligation to provide a data subject with access to their data or something like that, everyone benefits from those kind of good governance practices. From a corporate perspective, I think the GDPR could be a little bit more flexible. There are some concerns that it's a bit prescriptive, that it has the potential to make innovations like artificial intelligence and blockchain a little bit more difficult. But it's certainly inspiring, I think, countries all over the world. Thailand was cited as implementing Asia's first kind of GDPR modeled law, or the closest to GDPR that the Asia Pacific region has so far. There is a lot of interest, in general, whether it's from the GDPR, from kind of increasing proposals to restrict the flow of personal data across borders, for different countries to enact data protection laws. And I think Graham Greenleaf's latest count is something like 140 countries around the world have enacted some type of data protection law. Some modeled on the GDPR, some kind of following more of the Chinese model, and some taking a different approach.
So the GDPR does have these benefits, and that you have highlighted, but some feel that it maybe, isn't the only option out there. And I know you have been working on looking at Convention 108, the Council of Europe's, pioneering instrument in data protection as a complementary or similar source of data privacy protection. You want to tell us a little bit about your thinking about how could the GDPR be even better? How could it have been better, in the course of the negotiating that modernized treaty?
Certainly. Well, there are a couple of different answers to that question. First is that GDPR is one model, but some of the more flexible models that we've seen, I think, are the Canadian model, and some of the models and approaches that are being discussed in the United States, but that have not yet passed, such as, can we put some restrictions on the use of personal data? Can we ensure that personal data is not used to make decisions against individuals that are discriminatory, used in a way that manipulates them, kind of based on their personal data? I think the GDPR contains some provisions that aim for this, but I don't think it's necessarily as clear as some of the proposals we've been seeing from the United States, which have not been enacted yet. But there are definitely kind of different models out there. Certain things like data subject rights, I think, will likely be table stakes in any new data protection law that is passed. In terms of Convention 108, I think the original version looked a lot like the OECD privacy framework, which forms the basis for just about every privacy law that is out there. And the new modernized convention certainly looks a lot more like the GDPR. From the perspective of, I think, from a company, from the perspective of a government, from the perspective of an individual, I think it would be an ideal situation to have kind of a baseline of data protection, so that you can build one privacy compliance program, so that you don't need to negotiate adequacy agreements with many different governments, and so that as a data subject, you feel that you can give your data to any company in any country and ensure that it will be cared for and that you will have a remedy. And I can talk more about that later, but the Convention 108 is fundamentally a European model. It approaches data protection from a fundamental rights perspective. It has no parties from the Asia region. In Asia, the perspective is a little bit more from an economic standpoint. The APEC privacy framework seeks to facilitate trade and also safeguard personal data, but it doesn't come from a fundamental rights perspective. And I think the Council of Europe and the European Union have set the bar very high to expand kind of the adequacy through the GDPR and the parties that can accede to Convention 108, which unfortunately makes it seem rather unlikely that this will be the global standard anytime in the near future.
I think I read somewhere that the EU wants to join, see if it can accede to that convention. I know that would require an amendment of the convention itself, but that's a really interesting proposition. Do you think, where would that end? Where would that leave us in terms of data protection regimes if that were to happen? I mean, I'm just curious.
Again, Convention 108 sets a standard that is very similar to the GDPR, but it's not clear that it is a regime that can truly be globalized. And it's perhaps in Latin America, where European data protection law and the Red Iberoamericano, the data protection network, has established a framework which looks a lot like GDPR, is in a very good position to join Convention 108 and to set that kind of a baseline. But to accede to Convention 108 and I think to kind of be welcomed into the GDPR framework too, you need not only have a privacy law with certain fundamental aspects, but it needs to be a democratic society, and it needs to have an independent data protection authority. And Graham Greenleaf, again, has done some good work looking into this and determining that there are some countries that are kind of almost there, but they're not quite. And it looks like they will be left out of that attempt to kind of create this global baseline. So is there a way that we can make a baseline be truly global and give parties an incentive to join it? And that's kind of the question that has not yet been resolved.
Well, that's perfect. That is exactly the question I think that we want to highlight and leave on the table right now, and turn our attention to some practical implications of a global data privacy regime or the lack thereof. And I want to turn now to talk with Professor Margit Hu of Duke University about using technology to combat COVID-19 in the context of the global pandemic, and specifically the use of tracking technologies to try to control, right, the spread of the disease and the implications for privacy that we see everywhere as this type of technology gets rolled out. I was commenting with panelists before we went on live that just this morning there was a webinar co-sponsored by the Center for Democracy and Technology that looked at these issues of COVID-19 contact tracing applications in Europe, Asia, and the EU. So it is very much in the forefront of what people are thinking about now, and it gives us an opportunity to look at the practical implications of the broader normative principles and issues we've been exploring up to now. So, Margaret, if I may, can you tell us a little bit about how these technologies work, what's going on in this area, and what kind of challenge all that represents to the data privacy regimes like the GDPR? Whoops. I think you're muted. There you go.
Thank you so much, Arturo, for the opportunity to talk on this very important topic. And just to give a little bit of background on the rollout of these technologies. So after China and Wuhan became the first hotspot in which the COVID-19 was identified, China rolled out multiple surveillance technologies, requiring, for example, in certain cities, such as Wuhan, that the citizens had to download a health code app onto their smartphone, and it allowed for the tracking of the population. They used CCTV systems to detect high temperatures and fevers through thermal imaging. They deployed drones to broadcast public health announcements, to enforce health codes. And then multiple other Asian countries followed shortly thereafter. Singapore rolled out a Trace Together app that relied on Bluetooth signals. And then those signals were used to identify who somebody had been in close proximity with in order to notify those individuals if somebody had then shared that they had tested positive for COVID-19. And then South Korea followed, and Hong Kong, multiple other countries, India, rolling out similar types of digital contact tracing apps. South Korea's was considered particularly controversial in that those that downloaded this app were provided with the patient's nationality, age, gender, and geolocational data. Not only that they had been in close proximity with the patient that had been tested positive. And in the app that was used by South Korea, the geolocational data was compiled through an aggregation of vast amounts of databases. So including, in addition to CCTV footage, but also credit card histories and other geolocational data. And so this led to the calls for developing technologies, if they were adopted in the EU and the United States, to be differentiated from this type of mass data collection and aggregation and a lack of an anonymity of the data. And so that's where we are right now, developing new technologies here in the US and in the EU that might have more of a privacy by design built into it, and also a respect for laws such as the GDPR and new laws such as CCPA.
Well, thank you. That's a very helpful overview. There's been a lot of discussion of the Apple-Google collaboration in this respect, and how that might be rolled out. And you've drawn attention to the privacy issues generally. But what do you see happening in that with respect to that particular initiative?
Okay, so on April 10th, Apple and Google announced a historic partnership in which they were going to develop what they explained to be a common platform on iOS and Android phones that would allow the ability for those who were developing these types of tracing apps to operate on their phone systems. And then they had a follow-up joint conference on May 20th, where they named their new system the Exposure Notification Application Programming Interface, or the API. And they explained that through this API, because these systems necessitate running constantly in the background of the phone, that they needed to first minimize any kind of battery drainage. And then they allowed for the apps to log into the Bluetooth signals, and they would send out a short burst of data that would randomize a string of characters that would act as a pseudonym in order to make sure that there was anonymization of the information between the two phone users. They explained that this was a decentralized system, that they didn't intend for this data to be stored on any centralized database. Instead, that the encrypted information would be stored for a short period of time. They said 2 weeks on these servers, and that every 15 minutes, the phone would change the string of characters to further anonymize the user. And so this has been described as a Bluetooth handshake between two phones. And they said that this signal could determine how close the individuals were within proximity of each other based on the strength of the signal. And so Apple and Google have been contending that this is very privacy protective, and that it relies on users to voluntarily download the app. So they said that, first of all, this is not going to be a mandatory system, and that also individuals would voluntarily, once they downloaded the app, then they would voluntarily agree to share that they had tested positive, so that the individuals who were close proximity to each other would be informed that they had just come into some type of close geolocational range of somebody who had tested positive.
And so what issues from a GDPR perspective are you seeing with the rollout of this technology?
Well, what's very interesting is there are several countries in Europe, so including UK, originally Germany, France. There's some countries that really believe in more of a centralized data approach. And so even with the GDPR, even with Europe having stronger data protection regimes than the United States, the argument for centralizing the data is that it would allow for more efficiency in identifying how to slow the spread. If you can have some type of aggregated database that allows for public health officials to access very quickly, see the trends. And so some of the countries in Europe have argued that you can still do it in a way that protects privacy and the GDPR and still centralize the data. But there's been a real push by other countries to make sure that this is decentralized, that the data primarily stays on the individual's phone, that you don't have a central database in order to prevent misuse and abuse of the data. But the European Data Protection Board, in response to the Apple-Google announcement, have issued what they consider to be the primary principles that should guide the app developers in order to make sure that there's full compliance with the GDPR. So some of the underlying principles that they have published are that the digital tracing apps should be voluntary, anonymous, there should be an emphasis on security, and that there should also be only the collection of data that allows for proximity information and not pinpointing the geolocational movements of the individual users. And they said that you must also have an emphasis on the limitation of the storage of the data, and to the extent possible, not having the data that's being collected for pandemic purposes shared with others that do not necessarily need the information. So they warn against sharing it, for example, with law enforcement, or with having that data that's being used through the app to then seep into commercial advertising.
Wow, that is very enlightening and helpful. And it also underlines the importance and the role of technology, the technical aspect of privacy protection, and how it interfaces with the normative framework. And I think that's a perfect topic on which to segue to our final speaker, Dr. Andrea Matwishin, who brings to us expertise both on the technical as well as the legal side. Uh, would you like to, Andrea, share your thoughts on what you just heard Margaret discuss and any other aspect of the presentations up so far from your perspective?
Sure. So I think Margaret wonderfully highlighted that there are two distinct aspects looking at questions of data protection through a US lens. So data protection as a European term encompasses two different bodies of law from the US perspective. One being privacy law, which we've discussed extensively to this point. The second being the body of law around information security questions, which we've hinted at and referenced a bit less to this point. So I'll flesh out that conversation around security a bit, because GDPR is perhaps most game-changing on the point of its general approach to security questions. One of the most notable aspects of GDPR from the standpoint of those of us who focus heavily on questions of information security is that it adopted a changed approach. The earlier approach was more of a breach-centric approach, particularly in the way that US entities were interacting with the dynamics around data protection in the European Union from the security standpoint. GDPR shifted that toward the process-based security by design model, which involves proactive consideration of security risk and assessment of adequacy of systems in terms of defending the security of the information and the integrity of the system itself. So just to back up a little bit, the questions of privacy and security, both from a technical and correspondingly from a legal standpoint, they ask slightly different questions. Privacy relates to the identifiability of particular individuals based on information that exists provided by an individual or within a system. We're talking about identifying an individual from traffic analysis, from metadata, from technical constructs such as those. But when we're looking at the questions of security, we're actually looking at the system level and whether the system itself can successfully defend against attacks on the system's confidentiality, integrity, and availability. So we're not talking about any particular individual whose data is contained within the system. We're looking at the system as a whole and the sufficiency or adequacy of that system to defend against an attacker. So in the security analysis, we have a binary question in a way that we don't have in the same way in a privacy analysis necessarily. So on the security side, the system either successfully defends or it does not successfully defend. And where GDPR introduces this more nuanced analysis is that it then starts to engage with what legal and policy consequences should arise from the failures to defend this information. So that may be a breach, but it may not be a breach. It may be simply the ongoing inadequacy of measures to foreseeably defend against an attacker successfully, changing the settings in a system, transposing digits within a system, or exposing information that the system alleged itself to be successfully defending. And that may be personally identifiable information, it may not be. But the bottom line is that if the system does not successfully defend, it is not in possession of robust confidentiality, integrity, and availability protections. So if you look at the recitals, in particular recital 49 and recital 83 of GDPR, you start to see this shift in the overall approach in data protection that GDPR heralded. The data directive from 1996, and as it was implemented in various member states, it did not have this kind of a security presence so robustly reflected. In Article 5, you see greater detail in GDPR about what we mean by the adequacy of these security measures, including invoking well-established organizations such as CERT and the default norms of risk assessment that exist in technical communities. So this is a marked evolution. And Article 32 is another place in GDPR where we see the shift toward this proactive security by design model rather than a reactive breach-centric approach, which we in the US have been somewhat slow to disengage from in favor of the more effective proactive model of security.
So it sounds like you think that the GDPR has got it right in terms of moving towards that proactive approach. Is that fair? I mean, is this the standard that we want around the world?
The mindset that it reflects. We can debate the particular word choice. We can debate the particular framing of requirements. We can debate whether 20 million euro fines are not aggressive enough or too aggressive, but the idea of security by design is the only model of security that can succeed, and it is reflective of the default knowledge of the technical community with respect to how a sophisticated entity that cares about the security of its systems needs to approach its own defense of its systems against hackers.
And it seems like some of that we saw in the contact tracing discussion as well. This idea that you have to build it in by design up front, security as sort of privacy on steroids, right? It's the whole system. It's everything at once. Well, thank you very much for that. And so we've learned about different aspects of the GDPR, how it's applying in practice in the context of the pandemic, and this change in mindset that it promotes to look at security proactively, and why that actually is better for privacy, data privacy overall, and alternatives, both in the U.S. and elsewhere. So what I'd like to do now to wrap up the panel, first thank everyone for their presentations and input, which has been, I think, fascinating and enlightening. But give each of you a chance to comment, reflect on what you heard your other panelists say. And you have a good solid 3 to 4 minutes if you want. I'm feeling generous today. So why don't we go back to the beginning? Odia, I'd love to hear your thoughts on Andrea's characterization of what the GDPR does in the sense of security and in the U.S. Why are we slow to head in that direction, or any other aspect of what you've heard today that you want to comment on?
So I think slow to head in that direction. From my perspective, I would say potentially because the enforcement hasn't been there. Because I think the concept of a sort of risk-based approach and reasonable security and what that means, I think we have a lot of writing and guidance from the FTC. The FTC has all of the enforcement actions, and the start with security, and then the continue with security, and then the recent big enforcement actions where they were actually very specific about what they are looking for in a kind of comprehensive information security plan. I think that again is going to take. I think it's going to take time for people to take it seriously, and it might be down to right now under CCPA, right? One of the pretty much the only, unless we are proven otherwise by the new claims that have been filed. But technically speaking, under CCPA, the only private right of action belongs to a data breach resulting from a failure of reasonable protections. That is definitely going to result in some, detailed jurisprudence as to what reasonable means, and then people will also understand what it means. So before, 3-4 years ago, the claim was, okay, well, we have no idea what reasonable means. You never told us. Enforcement actions aren't helpful. This is behind the scenes, blah, blah, blah. So since then, okay, we got some more color as to what this means. But now it's like, we know what this means, but why do I care, right? So I think that, I think that CCPA also is going to change this, because I think as soon as, and the US has been like, GDPR has been a game changer in data protection. The US has been a game changer in data breach, litigation and class action lawsuits and everything, right? Like, we can totally set an example here. So I think once litigation starts on this, I think it'll be different.
Well, thank you for that. Liesl, do you want to add your thoughts imparting to what we've heard on all these fronts?
Sure. I think that everything I've heard, ties into the theme that we're working toward. Can we establish kind of a global baseline set of protections for data protection? And on one hand, there's momentum coming from the companies, the multinational companies, who are creating a program to comply with GDPR or another law, and then imposing that on other companies through contract. There's momentum from individuals who are being asked to use contact tracing apps or other technology that collects sensitive information about them, and perhaps are not confident that the law adequately protects how that data is being collected and used. And then there are high-profile data breaches and data security incidents that have impact across country lines. When you think of some of the Marriott and the Uber cases that involve different enforcement actions being brought in different jurisdictions, kind of on the same set of facts. And the calls by the OECD and other organizations to come up with a better way to coordinate global enforcement. Those are all factors kind of pushing us toward a global baseline. I'm not confident that it's going to look the same in every country. I think Asia will take its approach, and its regional organizations, APEC and ASEAN, will kind of coordinate that. The European Union and Latin America will be on their side with GDPR, with Convention 108. Africa actually seems to be working toward a kind of a common set of principles, and then pushing its countries toward data protection laws. And it will be interesting to see which way those go. And I think that there will be kind of a series of mechanisms to make these regimes interoperable, to ensure that businesses can do business in different regimes with different laws on data protection, that data can flow across borders, but that it's going to be kind of a little bit ad hoc. And so it will be kind of a patchwork that gets sewn together, perhaps.
Yes. Well, it also, I think that's a wonderful wrap up and tie in of all the different data that we've been referring. And what I'm gathering is that you're seeing kind of like the waters raising the levels a little bit, even if the way they're navigated might be slightly different. The baseline is evolving and becoming more protective, both normatively and also technically, right, in terms of security and cybersecurity. Margaret, you want to thank you for that, Lisa. Do you want to, Margaret, share with us your thoughts as we wrap up?
Yes, definitely. I think that one of the most important questions raised by COVID-19 pandemic surveillance technologies that have been introduced in the last few months is the limitations on data protection laws. I think if there's not a requirement, for example, the European Commission had asked, what is the responsibility of these companies or governments that are introducing these technologies to show that they're really going to be effective? Or what would be the responsibilities to assess their efficacy in actually slowing or stopping the spread of COVID-19 once the technologies are introduced? Or will we just have a rush towards the embrace of technological methods for contact tracing, for example, when in the past that's been conducted by trained health professionals who would do in-depth interviews with individuals who'd been infected to try to then recreate the web of other individuals and the likelihood that the network of community that they've come in contact with might have then also contracted the disease. And so I think that, once we have the technologies, it's hard to put the genie back in the bottle. And so you do have things like GDPR and CCPA, you do have these attempts to try to implement some type of data protection or some type of information security baseline in order to protect against abuse and misuse. But what about stopping the technologies in the first instance if they're not going to be effective? And whether or not you centralize the data or you decentralize the data that's being collected through some of these digital tracing apps, both of them have risks. And so even if you have the decentralized model that's being proposed by Apple and Google, there's a concern that, you know, you still are able to have, even with the best encryption systems, are you going to potentially have hacking? You have IP addresses that might then trace back to being able to de-anonymize the users. And so I think that there's just a lot of questions that remain open in these earliest stages of the introduction of these technologies, and especially the aggregation of the data. So we've been talking about, the Apple-Google collaboration was intended to try to make sure that the information was not only decentralized, but also that you disaggregated the data. But a lot of countries are moving to a model of mass aggregation of data. And I think that that imposes a lot of risks.
Okay. Well, thank you for rounding out that perspective. And I think we will conclude with Andrea sharing her final thoughts on the panel as a whole and reflecting on what you've heard. So take it away.
Thank you. So I think that we've had a fantastic conversation demonstrating some of the conversations that are happening more broadly. We're looking at the back and forth between the US and the EU in conversation with each other. Right. We were ahead on data breach. The EU is now ahead of us in terms of more holistic analysis of security of systems. The EU is ahead of us on generalized privacy considerations and data protection generally as a dignitary construct. We're now thinking through some of these same issues, not only in the contexts that we've already addressed, children's data, financial data, health data, but now more broadly with the repurposing and reuse of the kinds of general data that might be collected by things such as the COVID-19 apps that Margaret mentioned. The last piece that we've also hinted at is that the private sector has an important role here. So for example, the International Standards Organization has promulgated standards such as 29147 and 30111, which are creating also a baseline of care for sophisticated commercial entities. And those baselines that are arising sometimes most clearly in the private sector are also showing up as inspiration for legal frameworks that are then rolled out on a national or international level. And I think the ending point, echoing something that Margaret's comments highlighted, is that we're moving toward the bigger question of not only how do we build it and how do we protect it, but what do we mean by innovation and should we be building things? Do we have a substantiated basis for believing that this technology will perform in the ways that we hope and dream that it will? And whether that is taking us toward the kind of society on a national or international level that can materially improve the lives of humans and the international system as a whole.
Well, that's great. We started with the big question and we ended with the big question, but we covered a lot of ground in between. And I agree with Andrea and others' opinion that it was I think a vibrant conversation and I know I learned a lot. And so I want to wrap up by thanking each of you, the panelists, for joining us, and ASIL for hosting this panel, and to you, the folks who actually went on and checked us out. We hope you enjoyed it, learned a lot as well. So thank you to everyone.